If you or someone you know is planning to move to the UK, apply for a visa, or settle permanently, then the next few minutes could genuinely change the direction of your plans. Because right now, the UK immigration system is going through one of the biggest shake-ups it has seen in decades. Rules that were in place just a year ago are already outdated. New rules are already live. And even more changes are lined up for the months and years ahead. So whether you are a skilled worker, a student, a family member trying to reunite, or someone who has been building a life in the UK and is looking towards permanent residency, you need to hear this. Stay with me, because we are going to break down everything clearly, in plain language, so you know exactly where you stand. Let us start with what is already in force right now, because some of these changes caught a lot of people off guard. The English language requirement for new skilled worker, scale-up, and high-potential individual visa applicants has increased from B1 level to B2 level as of the 8th of January, 2026. To put that in perspective, B1 is roughly equivalent to a GCSE level of English, while B2 is closer to A-level standard. This is a significant jump, and it is not just the main applicant who is affected. This change also applies to the dependents of skilled workers on these routes, with anyone over 18 required to demonstrate B2 level English. There are some exemptions, such as being 65 or older or having a physical or mental condition, but for the vast majority of applicants, this new standard now applies from day one. Now here is something important if you are already in the UK on one of these routes. Transitional arrangements are in place allowing existing migrants to continue under B1 when extending their permission. So if you are already here and just extending, you are not automatically required to meet the new B2 threshold. But if you are applying fresh from outside the UK, B2 is now the minimum standard. This is not something you want to discover at the last minute. The Electronic Travel Authorization System, or ETA, is now being strictly enforced from the 25th of February, 2026. Non-visa nationals will no longer be able to enter the UK without an approved ETA from this date. Countries affected include the USA, Canada, Australia, most of Europe, Japan, South Korea, and some Gulf states. British and Irish citizens remain exempt. The ETA costs £16 and is valid for 2 years or until the passport expires. It is electronically linked to a specific passport, meaning that if you renew your passport, you will need to apply for a new ETA. Each traveller, including children and infants, requires their own ETA, and the Home Office advises applying at least 3 working days before departure. This is particularly relevant for business travellers and people visiting family. If you have international colleagues or clients who regularly come to the UK, this is something they need to know about right now. Let us talk about the skilled worker visa more broadly, because this route has seen some of the most dramatic changes. The minimum salary threshold for a standard skilled worker visa was increased from £38,700 to £41,700 as of the 22nd of July, 2025. At the same time, the skill level requirement was raised to RQF Level 6, which is equivalent to a bachelor's degree, and over 100 medium-skilled jobs were removed from the eligible occupations list. Many of those jobs were moved to what is being called the temporary shortage list. The temporary shortage list allows recruitment of overseas workers in roles that do not meet the higher skills threshold. However, skilled workers with jobs on either this list or the immigration salary list can no longer bring dependents to the UK. That is a major change for families. If your job falls into one of these medium-skilled categories on the temporary shortage list, you cannot bring your spouse or children with you. That is a personal cost that goes far beyond salary figures. The temporary shortage list itself is set to expire on the 31st of December, 2026. Unless the Migration Advisory Committee recommends that the list continues, those occupations will no longer be available for overseas sponsorship beyond that date. Now let us talk about the costs involved, because they have gone up significantly as well. The immigration skills charge increased by 32% from December 2025. For large sponsors, this is now £1,320 per sponsored worker per year, up from £1,000. For small and charitable sponsors, the fee is £480. Sponsor license priority service fees also increased from £500 to £750, and sponsorship management priority service fees rose from £200 to £350. These costs are borne by employers, but make no mistake, they affect hiring decisions. When it becomes more expensive to sponsor someone, some employers will think twice before going the international route. One of the most talked about and debated changes right now is what the government is calling earned settlement. This is a proposal to overhaul how people qualify for indefinite leave to remain, which is the permanent residency status that allows you to live and work in the UK without any restrictions. Under the current system, most people qualify after 5 continuous years of lawful residence. The government wants to change that dramatically. The government has proposed extending the qualifying period for settlement from 5 years to 10 years for most sponsored work routes, introducing a points-based earned settlement system. The consultation document that followed indicated the government's intention to apply these changes to everyone already in the country who has not yet received indefinite leave to remain. That means people already on the path to settlement would be subject to the new requirements as soon as the immigration rules change. The Migration Observatory, an immigration research project based at Oxford University, said that the government's plans to lengthen the route to settlement would make the UK more restrictive than most other high-income countries. The Institute for Public Policy Research described the plans as completely out of line with most of the UK's counterparts and warned it would create a near-perpetual state of insecurity for migrants, with major implications for integration. 2 petitions against the changes gathered over 232,000 signatures and were debated in Parliament in early 2026. The level of public and political concern around this issue is significant. If you are approaching your 5-year mark and are close to being eligible for indefinite leave to remain, the advice from immigration specialists is to consider applying before April 2026 to avoid transition to the new earned settlement system. The 10-year long residence route, which previously allowed individuals to aggregate time spent across different visa categories, will also be abolished under the new plans. This will affect those with complex immigration history significantly. Let us also talk about overseas care workers, because this is a community that has been particularly affected by the recent changes. Overseas recruitment of social care workers ended on the 22nd of July, 2025. That door is now closed for new applicants from abroad. Workers already in the UK in the social care sector do have transitional protections in place, but anyone hoping to come from overseas specifically for care work will find that route is no longer available. Now let us look at what is coming next, because the changes do not stop here. From the 8th of April, 2026, sponsors are required to pay skilled workers their full required salary in every single pay period, allowing the UK Visas and Immigration Authority to identify and address any underpayment earlier through corrective or compliance action. This is a compliance change that affects employers directly, and failure to comply could put sponsor licenses at serious risk. A new measure known as the visa break took effect from the 26th of March, 2026. Under this measure, all skilled worker visa applications from Afghan nationals, as well as student visa applications from nationals of Afghanistan, Cameroon, Myanmar, and Sudan made from outside the UK, will be refused, even where a certificate of sponsorship had already been issued. This measure is being kept under review. It is an extraordinary step, and it has raised serious concerns among humanitarian and legal communities about the fairness and proportionality of blanket refusals based on nationality alone. A further adjustment to the Global Talent Visa is planned, adding a dedicated pathway for the design industry, which will take effect on the 1st of July, 2026. This is one of the few genuinely positive expansions in this round of changes and is worth watching if you work in the creative and design sector. Graduate visas will be reduced from 2 years to just 18 months for new applicants as of the 1st of January 2027. However, PhD graduates will continue to receive 3 years. This is a significant cut for international students who were counting on that 2-year window to find sponsored employment after graduation. 18 months is a much tighter timeline, especially in competitive job markets where securing a visa-sponsored role can take considerable time. A higher standard of English language will also be required for indefinite leave to remain across various visa routes from the 26th of March, 2027, raising the standard from B1 to B2. So not only is the path to settlement potentially getting longer through the earned settlement proposals, but the language bar at the very end of that journey is also being raised. Changes to student visa compliance rules for universities are expected around June 2026. Universities will face tighter responsibilities around monitoring and reporting student attendance and compliance. This could affect how institutions admit and manage international students going forward, and could influence which universities international students feel confident applying to. Looking at the bigger picture, all of this sits within the government's stated goal of reducing net migration significantly. In the year ending June 2025, net migration to the UK was estimated at around 200,000 people, which was roughly two-thirds lower than the previous year, when it stood at approximately 649,000. The government wants to bring those numbers down even further, and the white paper published in May 2025 is the blueprint for how it intends to do that. The UK immigration landscape stands at a pivotal moment, shaped by far-reaching reforms and evolving political pressures. The cumulative effect of recent and upcoming changes signals a clear shift towards an even more conditional immigration system. This is not just about numbers and policy papers. These are real people, real families, real careers, and real lives being shaped by decisions made at the very highest levels of government. So what does all of this mean for you, practically speaking? If you are planning to apply for a skilled worker visa, make sure your English language certificate is at the B2 level before you even begin your application. If you are an employer sponsoring overseas workers, budget for the increased immigration skills charge and be ready for tighter salary compliance monitoring from April 2026. If you are approaching 5 years of residence in the UK, speak to an immigration lawyer now about whether you should apply for indefinite leave to remain before the earned settlement rules come into force. If you are an international student, understand that your graduate visa window after finishing your degree is likely to shrink to 18 months from January 2027, so your job search strategy needs to adjust accordingly. And if you are traveling to the UK from a visa-free country, make sure your electronic travel authorization is sorted before you even think about booking your flight. The UK immigration system is in a state of rapid and sustained change. Staying informed is not just useful, it is essential. Missing a deadline, overlooking a new requirement, or being caught off guard by a rule change can have consequences that are very difficult to undo. That is exactly why we are here, to keep you updated, break everything down in plain language, and make sure you have what you need to make the right decisions at the right time. If you found this video helpful, please give it a like because it really does help this channel grow and reach more people who need this information. Share it with someone who is going through the UK immigration process, because this could genuinely help them avoid a costly and stressful mistake. Drop your questions in the comments below and we will do our best to answer them. And most importantly, subscribe to my channel so you never miss an update. The rules are changing fast and you want to be the first to know when they do. Hit that subscribe button right now and turn on the notification bell so every time we post a new video, you are the very first one to see it. We are here with you every single step of the way.